So what I'm going to talk about are the issues, then I'm going to talk about why do we care about this in Alberta, because of course all of this is, the facts are happening in Manitoba. Okay, so let me talk about Manitoba, and then I'll talk about why is this relevant in Alberta. Is that okay? Okay, so 3 declarations are being sought in this context. I'm just going to refer to my notes so that I get this accurately. The first declaration is that the federal government breached its fiduciary duty in implementation of these sections I talked about. Section 31 being the one that talks about the land grants to the Métis children, and Section 32 being the one that talks about respecting the possession of settlers and their land interests as well. Okay, so that's the first declaration. The second one is the federal government failed to implement these sections in a manner consistent with their honor, with the honor of the Crown. And then the third declaration that's being sought is that certain legislation that was enacted to implement all of these provisions and promises were unconstitutional. So I'm going to talk about the land and trust question. I'm going to talk about fiduciary obligation, and I'm going to talk about honor of the Crown, and I'm going to explain what those are. Okay? But before I do that, I'm going to talk about a couple of other issues in the case. So in trying to answer these questions, and in deciding whether or not to issue the declaration, there were bigger issues that had to be considered that actually have implications for Métis, First Nations, and Inuit as well. And this is because a fundamental issue was whether or not the promises that were made in negotiations between the Métis and the federal government compelled the Crown to act to a certain standard of conduct. Okay? So that this idea that promises that are made that are then protected in a constitutional instrument can compel Crown conduct can apply in modern treaties, it can apply in land claims, and it can apply in other contexts. So this is very important. They had to think about this in order to decide whether or not to make a declaration. Another issue that the court had to think about in order to make this declaration is what is the scope of this fiduciary obligation and what does it mean? So I'll talk about that. Okay. And the other reason this case is really important, and another issue that it addresses, is what do we mean by honor of the Crown and how do we give it teeth? And what is very significant about this case is it actually creates a standard of conduct for us to measure the Crown and to say, you fulfilled your honor or you breached it. And this test that we can apply to ask, did the Crown follow its obligation or did the Crown breach its obligation? Again, we can bring into some other context. We're going to be able to bring it into Alberta. We're going to be able to apply it to a modern land claim. And we're going to be able to apply it to some other context. So this is really an important case for that reason, not just for the Métis, but all Aboriginal peoples of Canada, in my opinion. 2 other things that came up in this case. I mean, it's really, really a dense case. The Crown argued that the Manitoba Métis Federation should not be able to bring this case forward because of the application of what we call a limitation period. Now, every province has legislation that prevents you from bringing an action before the court once a certain period of time has passed. The reason for that is well, there are many reasons, but one of them is it's thought that it would prejudice the defendant because so much time has passed, it's hard to get the evidence. You can't bring the real live people before the court, right? Many of the people, of course, well, all the people who are involved in negotiating Section 31 are no longer with us. Their memories are, you know, and their children and their descendants are, but they're not, right? So the argument of the Crown is that these limitations should have applied and that this case could not go forward. Now, the Crown's argument was upheld at trial and at Court of Appeal on that point. Even if one of these statutory provisions is inapplicable, that is, even if the Crown failed on that argument, they could make another one that could prevent us from going to court. And that is called the equitable doctrine of leges. It's a Latin term, stupid term. We have all these old terms in law still, leges. And the idea is that if you are bringing a claim in equity, like honor, that raises the conscionability of someone's conduct, again, you must bring it in a timely way because it can prejudice the other side. But what's really important is that both sides, we have to look at the conduct of both sides and the conscionability of the conduct of both sides. And in this case, the court is saying that we are not going to allow leges claims to block a claim based on dishonorable conduct when what we see is a pattern of historical injustice and a power imbalance. Okay? So these are phenomenal findings for all Aboriginal peoples in Canada, beyond what the court is going to say about Métis rights.